Welcome all to our webinar, US, China, and Europe views on Inventive STEP. This is the second of 4 webinars that is energized by the Israeli AIPPI national group. For that, I want to thank very much my collaborators in the board of the Israeli AIPPI group, especially for President Asa Kling and the Secretary Ran Vogel. I am Eyal Bressler. I am the treasurer in the AIPPI Israeli group. I am the chair for the AIPPI Standing Committee of DIP, Development and IP. I'm a patent attorney in attorney at law in Israel. This session is recorded. The record can be retrieved from the AIPPI event. AIPPI event managed today by Cynthia and Maria is a wonderful group of women that helps us in everything. So all the thanks for the AIPPI events and Cynthia and Maria. My thanks are also for the distinguished speakers who will present later on. So without further ado, I wish to earn my 3 minutes of glory by somewhat schematically illustrating my understanding of the way I teach KSR versus Teleflex, relating with the person having an ordinary skin of the art, the Fushita, and the telling, suggesting, motivation method of analyzing, the TSM method of analyzing. So you see here a patent. The patent belongs to at least one field of invention, namely International Patent Classification. The patent comprises 3 different phases: a background, a description, and in between buried a set of claims that are relevant to this field of claims. The KSR Teleflex case in my presentation showed here by a novelty destroyer, X type cited document, D1, which is within the scope of the claims, within the description. On the right illustration is the Inventive step destroyer citation of D2 and D3. Both D2 and D3 are outside the scope of the claims, but within the field of invention. And KSR Teleflex says that there is a Fushita, there is a person having an ordinary skin in the art, and this legal person is collaborating between D2 and D3 in his mind in a telling, suggesting manner. You'll see one of those combinations that D2 and D3 are collaborated by the Fushita in a well-defined manner. There is a very narrow line between D2 and D3, and there is another way that the wide scope telling by the Fushita, and you see also the telling, and you see in the shadow, you see the suggesting. This is the telling, and this is suggesting. Now, this is only one IPC and one Fushita. You can have multiple Fushitas in 2 documents. You can have at least one Fushita, which is, let's say, a synthetic chemist, reading a document and combining with another document. And you can have another Fushita, let's say, biologist, who read the same documents as his own understanding. And of course, this is my last slide. You can have a multiple field of inventions. You have the blue invention, blue field, and the red field, the first IPC, the second IPC. So you can see in the blue field from document D2 and document D3, the biologist combining in one way, the chemist is combining with a second way, and an engineer with looking at D4 is combining in another manner. So all of them are the Fushita of the KSR. This is my presentation. We'll speak quite a lot about the Fushita and the KSR. I know that Jeff Lewis will speak about in a few slides. And if you like my presentation, or better, if you don't like my presentation, please comment in the final Q&A session that we'll have, and the very final step of the invention of the presentation. Now, without any further ado, I wish to present Jeffrey Lewis. Today is with the Foley Hague. In 2 decades ago, it was with another firm representing his case in the KSR Teleflex in the Supreme Court. A few words about Jeff. I can tell him about him for hours, but just a few words. He's a patent attorney. He's coming from chemical engineering. Oh, I found it. He's involved with numerous litigation matters and numerous fields. He shows his cases before the U.S. Federal District Courts and other tributes and the Court of Appeals of Federal Court circuits, and as you know from the KSR, also from the Supreme Court of the United States. Jeff is a past president of the AIPPI and AIPPI. He's currently chair of the AIPPI Standing Committee of Amicus Briefing Committees. Jeff served years ago as an adjunct professor in Cardozo School of Law, and is constantly recognized as numerous publications such as Chambers. In my opinion, Jeff is one of the leading professional patent attorneys in the world, and I'm really keen to listen to you. What do you think? You phrase your lecture as, is there a step between inventive and non-obvious comparing the US standards? So, Jeff, please.
Oh, Ayal, between your explanation of KSR, which was so good, and your embarrassment of me, I should probably just sit down and be quiet. But I have still a few thoughts to share, and so allow me, please, to do that. And I'm indebted to my colleague, Stuart Knight. He is with us here at Foley Hoag. He first qualified in London before he came to the United States. And so you'll see that I'm doing a lot of discussing of comparison to help people understand the difference between the United States standard and the standard in both Europe and Great Britain. And that is in my debt to Stuart, because he added the stuff that's not the United States, which was quite helpful. The very common language between how we describe things in the United States and how it's described in EPO and UK. We both use the word obvious. We question whether it's obvious. UK and EPO question whether it's obvious. It's a very easy word, but the differences are not in the statutory framework. The differences are actually how each of the institutions, each of the regions apply that. And so let us remember our friend Oscar Wilde, who is widely attributed with having talked about English being in two different areas, the United States and Great Britain, and saying that our countries are divided by a common language. And so I would say to you that here we have two bodies of law divided by a common language that we both use obvious, and it means something a little different. In the limited time I have today, I'm going to just talk to you about a few things. The statutes, always a good place to start. a little look at how non-obviousness in the United States and inventive step are looked at. And again, I apologize for my US understanding of these standards as applied elsewhere. Then what constitutes prior art in our various regions, how to combine prior art in our various regions. And I'm going to spend a moment talking about secondary considerations and objective indicia, because I think you'll see that there is quite a significant difference between the jurisdictions on how we treat evidence outside of the patent document and the prior art. And then finally, time allowing, I will briefly address the concept of obvious to try when it's obvious to try something from our various frameworks. So we start with the statutes, and our statutes are very clear, but phrased quite differently, which is if you look in the center at the United States Code, you will see it says a patent for a claimed invention may not be obtained. This perhaps reinforces a wide impression around the world that Americans are very negative, because under TRIPS and under the EPC and UK statutes, those are positive grants. Those are positive statements. The patent shall be granted. And so we start with this sort of fundamental premise, and I think there's a bit of a psyche, there's a bit of a psychological and mindset that can be carried forward into how these codes and statutes have been interpreted, because that's the mindset of starting with it would not have been obtained if it would have been obvious, versus it shall be obtainable or available if it involves an inventive step. In the United States, our concept of obviousness actually was not originally statutory. It goes back to 1851, which at least to our country seems like a long time. And our Supreme Court looked at how to analyze whether an invention is new and said if it would be an obvious variant in a case called Hotchkiss versus Greenwood. As Ayal brought out, one of our leading cases at the moment is a case called KSR. I'll talk about it a little more in a moment, but it looks at whether those advances are a new threshold from which the innovation starts once more, and goes on to say that the results of ordinary innovation ought not to be patentable. You're not going to get the subject of exclusive rights under the patent laws for ordinary innovation. It has to be something a little more in order to, as this quote ends, promote the progress of useful arts. That is a phrase that finds its origin in the United States Constitution. We actually have a US constitutional right to patents and copyrights in order to promote the progress of science and the useful arts. And so the question comes back to, under KSR, are you really progressing the useful arts? By the way, for those who are curious, it is called science and the useful arts because in the old days, science referred to the study of literature, right? The College of Arts and Sciences. It was always, arts was something mechanical and science was something literary and thoughtful. So it is the progress of useful arts. So we look now at what the standard is under TRIPS, and as has been brought forward in EPC and by its Patent Act of 1977, the UK enacted Article 56, and question becomes, what's the inventive step? May it be deemed by a member to be synonymous with the term non-obvious and useful, respectively? And you see that in both TRIPS and in the European Patent Convention. Similar language in the UK. Again, using the same words. How does that end up being applied? This is a rather tough chart, but Stuart and I tried many ways to map out how the non-obviousness framework aligns itself, because you'll see that many steps line up, and we've done it with color. Hopefully people can appreciate the color on your screen, but we've done it with color to show that almost all the concepts align between the three jurisdictions. There are some differences between the EPO and UK. In some ways, the UK is closer to the United States, but If I look at the Graham versus John Deere test in the United States, which comes from a Supreme Court in 1966, if I look at the guidelines for examination in the EPO, and I look at windsurfing case from 1985 in the United Kingdom, as well as the more recent Pozzoli case, 2007, you'll see that the main difference is the ones that I've highlighted in red. Establish objective technical problem to be solved in EPO and identifying technical effects. I think there are some concept level statements that can be made about what the difference is in the United States. The UK is somewhat similar to the United States in terms of how it does the analysis of prior art to see if there's been this inventive step. But one of the differences between the UK and the United States is it seems like the UK looks at invention holistically. It's going to look at the patent disclosure and really focus on what is the concept of the invention underlying it. In the United States, we are very literal. Our patents end with claims, and as Judge Rich, who was one of the drafters of the patent code, said, quote, "The name of the game is the claim." And so in the United States, we're quite literal, and we look at claim by claim for the validity of each claim. We don't look at the validity of a patent, we look at the validity of a claim, and we do that, and it could be different prior art, different combinations of art that are relevant in each claim. And again, the UK looks at it much more holistically. In the EPO, what are the technical effects? What's the real world effect that arises from the result of the technical features? And we'll look at, again, one of the UK cases in a few moments. But I think one of the differences can be characterized, if I can say that, by thinking of where it's the identification of the problem that implies the solution. And so where if the problem is itself, once identified, the solution becomes easy. In the EPO, getting to lack of inventive step is much quicker, requires less work in the EPO to get to a finding of no inventive step than in the United States or even the UK for considering whether that invention ought to be granted a patent. Looking at what constitutes prior art, again, here is a layout of the three areas. United States, we have a fiction, and our fiction is that the fosita, the person having ordinary skill in the art, that's an acronym, fosita, sometimes also called a posa, person of skill in the art. But the fosita has on the corkboard in front of them all of their inventions. All of the prior art is arrayed in front of them, and then it compares all of that prior art to the invention. And KSR goes to when that's appropriately combined or not. But we have cases in the United States that say things like familiar items may have obvious uses beyond their primary purpose, and a fosita can do that combination and look at multiple pieces like putting together a puzzle. But we also say that a fosita cannot search the entire universe. You can't go out to very bizarre, unconnected areas. And so I remember as a young attorney, I was involved in a case that involved those sensors, those buzzers that go off when somebody takes a piece of clothing out of a store and they've forgotten to take the tag off, right? That magnetic little block of plastic. And somebody tried to invalidate that patent using technology from cleaning fish tanks and magnets that are used to clean the glass of fish tanks from the outside with the cleaner on the inside of the fish tank. And the court said, no, that's, you can't go outside. That's way too outside of the technology area of a security device. And so in the United States, we do look at that much more closely. In the EPO, common general knowledge is always a question, and the UK, it's not enough to simply say a skilled person would have or have not discovered the document in the course of their work. There needs to be something more relevant. Because when we combine prior art in the United States, the KSR case, which I did a amicus brief on behalf of AIPLA, the US affiliate of AIPPI, KSR said, you don't have to have a literal suggestion, teaching, or motivation, what we were calling at the time the TSM test, to combine prior art. It has to be a much more flexible approach. It has to be a much more available approach to allow people to combine and look at prior art. And so it became very expansive. In the EPO, there's something, the problem solution test continues, where you can only bring in a second reference if there's something in the primary reference that makes you want to make that change. We actually have a test similar to that in the United States, dealing with chemical compounds. We call it the lead compound test. And when you want a chemical compound, you pick a lead compound, but you have to have a reason to make each variant. Well, in the EPO, in the UK, I would say you look for blaze marks to go to the next reference and bring it in. How does that get combined? So now I said I was going to spend a few moments on objective indicia and secondary considerations. We actually pay quite a lot of attention to that in the United States, much more so than in the European Patent Office or in the UK. Evidence of an unexpected result. Everybody thought if you add this and that together, you get a third thing, and it turns out you get something else. Evidence of teaching away, and we'll look at an example of this in a moment. A reference that criticizes, discredits, discourages the solution that was claimed in the patent that's being analyzed. And then there are the real world factors. Commercial success. Was there some long felt need that was not solved? Did others try to solve the problem and failed? And all of these enlighten us on the circumstances surrounding the patent and whether it should have been patented. So let me tell you about my favorite secondary consideration case. It's a case called ARCI Lures versus Jean LaRue Tackle. It's an older case, 1997. The patent was for a salt impregnated fishing lure. And this is I think, a very good example of how secondary considerations and indicia of non-obviousness are applied in the United States. Salty bait for fish, because apparently if a fish tastes the lure before they bite, and if it's nice and salty, it clamps down and the hook will set. It was well known to use organic attractants in lures that fish would like, but not salt. But there was prior art out there of salted pork rind being used on for fishing. There's actually a patent on a squirrel hair and yeast with salt fishing lure, and the drawing you see is actually from that patent. There's a patent on using there's a disclosure in a book of a frozen salted minnow, small fish. And you salt the fish, and then salt this frozen minnow, and then the fish that you're trying to capture tastes the salted minnow, goes yum yum, clamps down, gets on the hook. It also turns out that manufacturers of plastic lures had expressed doubt, this is a quote from the case, about the feasibility of manufacturing the device, the patented claim. They said it couldn't even be made. Why not? Because salt roughens the texture and reduces the tensile strength. The lure will just rip. And by the way, adding salt to plastics can cause explosions. So there was a definite teaching away from making a salt-impregnated plastic fishing lure. But when Jean LaRue introduced it, it was an immediate commercial success. ARCI Lures copied the LaRue lure. The experts testified that this lure revolutionized the fishing industry. And so all of these secondary considerations overcame a prima facie case of obviousness, and the patent was upheld. That's because in the United States, and this is a quote from Howard Markey, the first chief judge of our federal circuit, secondary considerations are not secondary in importance. They are secondary only in time. They are the real world factors of what happened after the patent was written and after the invention was disclosed. And so as Chief Judge Markey wrote and this was from a speech he gave and an article he published of the speech, and then he continued on to hold this in case law, real world factors should be taken into account. Now, in the European Patent Office, secondary indicia are only of importance in cases of doubt. In other words, they are secondary. And the focus stays on the problem solution test at all times. So there are factors that will be considered, but I would say they only get considered under the EPO standard in cases that are quite close. In the UK, there's a little more attention paid to secondary considerations and objective indicia. The UK looks at such indicia as long felt want, commercial success. It's like in the United States, but it is not as significant. And there's this case, Haberman versus Jackal International, which I commend to anybody who wants to follow up on it. It's about a sippy cup, those cups that you use for children as they're transitioning off of being bottle fed or nursed into finally holding a cup on their own. And it's about this little silly, simple invention of adding a squeeze valve at the top of the drink. It became a huge success. It was something that people did not want to commercialize. I commend this case to your reading if you're curious, but I'll just conclude. It's in the paragraph 30s and 40s. I think this is paragraph 33 that's quoted here. But on paragraph 45, the end of the whole analysis of whether the invention was inventive over the prior art summarizes a decision and says, Mrs. Haberman's patent discloses something sufficiently inventive to deserve the grant of a monopoly. And so that is the underlying question: was it sufficiently inventive? And so I conclude with obvious to try. Is there a valid approach to the motivation to combine in the United States? In the EPO, it becomes slightly differently analyzed. Was the reasonable expectation of success? And in the UK, it's reasonable or fair prospect of success. Oddly enough, though these sound similar, they go different directions. And I had a colleague who once described obvious to try law in the United States as saying, the law is obvious to try is never appropriate except when it is. And so with that, I ask you the question, is it inventive? Is there a small step between inventive and non-obvious or not? And I will just remind you of what Neil Armstrong said when he stepped on the moon. Sometimes what's a small step for man can be a giant leap for mankind. And so I can't tell you whether it's a small step between inventive and non-obvious under the various legal rubrics. That's a question that unfortunately gets decided on the facts of each case. But Ayal, I hope I've properly answered the question asked.
Thank you so much, Jeff. It is for myself, in case of obviousness, I think it's obvious that this term is not obvious worldwide, and we should speak about that. Our second speaker is Xiaofang Li. Xiaofang is coming from Beijing. CCIPT is a huge firm founded. I think it's the first firm in China, founded in 57. The firm is huge. It has more than 200 patent attorneys, 60 patent attorneys, and more than 100 lawyers. And with this whole bunch of very wise guys, Xiaofang Li, patent attorney, is a group leader in the electrical patent department. Xiaofang was studying MSc degree in electrical engineering, and and then as a LLP in Melbourne Hills, Great Britain, and is as a DIP of 15 years ago. She will speak about examination of inventiveness on inventions relating to an algorithm. It's a very, very important lecture. Thank you, Xufang, for presenting that while listening to you.
Okay, thank you. Yeah, I will share my screen. Yeah, is that okay? Yeah, first, I'm Xiaofang Li. First, I'd like to thank AI and AIPPI colleagues for organizing this webinar so that I have the opportunity to meet you all, although online, and introduce the recent Chinese practice, especially about the inventiveness of inventions relating to algorithm. As we have known, the algorithm-related inventions including AI, have been a hotspot in recent years. The major jurisdictions like US, EP, China, Japan, so on, have revised the related law and or guidelines to adapt these such changes. So today I will talk about the changes made by Chinese Patent Office. Yeah, first I will give some the guidelines provisions, then some typical cases from guidelines or shared by examiners, and last there is some tips for drafting specification in China. First, let's go through the provisions. Yeah, this is the Chinese statute for inventiveness. Yeah, it's much more or less the same as the most countries. Yeah, the invention has prominent substantive features and represents a notable progress. Yeah, this is new provision on inventiveness of inventions relating to algorithm. It has been effective as of February 2020. It says when examining the inventiveness of invention application, including technical features and algorithm features or business rule and method features, the algorithm features that functionally support each other with the technical features and have an interaction relationship with technical features should be considered as a whole with the technical features. Here, functionally support each other and have interaction relationship means that the algorithm features are closely combined with the technical features to form a technical means for solving a certain technical problem and can obtain corresponding technical effects. For example, if an algorithm you claim is applied to a specific technical field and can solve a specific technical problem, so then the algorithm feature and the technical feature can be considered functionally support each other and have interaction relationship. So the algorithm feature becomes an integral part of the adopted technical means, and contribution should be considered when examining the effectiveness of the claim. And this, in addition to the provision on the previous page, in September of 2021, the Chinese Patent Office published new amendments to the guidelines for soliciting opinions. But for some unknown reason, these amendments have not been effective so far. However, according to the examiners and our practice, the Patent Office has actually adopted these amendments during the examinations. The amendments add two paragraphs. The first paragraph provides a case where the algorithm, although not applied to a specific technical field, but has a specific technical association with the internal structure of the computer system. And the second paragraph provide a case about the user experience. Yeah, next, yeah, I will give some examples to better understand those provisions. These examples are from the guidelines or shared by examiners in some seminars. The first case is from guidelines. It's a method for detecting a falling state of humanoid robot. Here the case, we will go into every detail. Let's directly see the claim. It's a simplified one, but we can see the claim includes the algorithm to process. See the red portions, using fuzzy inference algorithm to process some information. Then the examiner found a reference D1. D1 also disclosed determine the stability of robots based on sensor information. As compared with D1, we can see step 1 of claim 1 is disclosed. The difference lies in the step 2, which use the algorithm. The guidelines conclude that the algorithm combining various information can realize a beneficial technical effect, such as can provide a basis for further setting accurate posture adjustment instructions. So the algorithm features and technical features support each other functionally and have interaction relationship. Thus, as a whole, solve a technical problem. So, so this algorithm and its application to a specific technical field, the robot steady state determination, are not disclosed in other reference, nor are they common knowledge in the art. So claim 1 has inventiveness. In case 2 is a case which has negative conclusion, that is, it does not have inventiveness. This case comes from a lecture by the patent office. The case is traditional mutual aid insurance solutions have some problems. So the invention provides a blockchain-based operating platform. This is a simplified claim. We can see the claim includes both the algorithm features like writing preset content and present rules into a smart contract and outputting amount according to the present rules. And also technical features like saving, writing, and cross-verifying. The examiner found reference D1. D1 has disclosed how to prevent information from being tampered with by storing blockchain data on distributed servers. So compared with D1, the difference lies in the particular information input the blockchain. Yes, this information input blockchain and output from the blockchain, such as amount, registration, reimbursement, and so on. So the examiner conclude that the implementation of the solution does not involve any adjustment or improvement of the technical means. The problem actually solved by the invention is not a technical one. So these distinguished features cannot bring any technical contribution to the solution and are not considered when examining the inventiveness. So the claim is not inventive. From these two cases, we can see that whether the algorithm features can be considered lies in whether the algorithm features and technical features in combination can solve a technical problem. If so, the algorithm features can be considered. Yeah, this case 3. This case also from guidelines. it's the proposed amendment to the guidelines. You may call that the proposed amendments add two scenarios. The first is that the algorithm has specific technical association with the internal structure of the computer system. Now, case 3 is an example for this scenario. It's a method for adapting neural network parameters. Let's direct see the simplified claim. We can see the claim include selecting dimensions, determine a size of weight parameters, and determine values populating the weight parameters. So can you see the problem? Yes, the claim is all about the neural network per se, not applied to a specific technical field. Normally, such claim will have no chance to get into effectiveness assessment, but will stop at the first place, the subject matter assessment. But this claim survives because it has step 3, based on utilization rate of hardware supporting the neural network computation. This feature relates to an internal structure of the computer system, so it helps not only passing the subject matter assessment, but also the effectiveness assessment. Yeah, let's see the examiner say. Examiner filed a reference D1. D1 disclosed the design method for neural network processor, which include these features. The difference lies in the following features. Yeah, red one. You can see most of the algorithm features, but the guideline conclude that by using this algorithm, the hardware can efficiently process the data, and algorithm in the solution improves the computing efficiency of the hardware. Therefore, the algorithm features and technical features support each other functionally and have interaction relationship. They as whole solve a technical problem. So the algorithm feature are considered when conducting inventiveness assessment. So the claim invention has inventiveness. Yeah, this is last case. This case comes from a lecture by the patent office. This case about user experience. Yeah, you may call that the proposed amendments. In the proposed amendments, the second scenario is about user experience. The case is implementing online customer service about how to distribute robot customer service and human customer service. Here the claim. Yeah, it includes both technical features like receiving customer service requests and obtain information and performing communication, and algorithm features like obtain access ratio, updating the access count values, obtain a new access ratio. The examiner filed a reference D1. D1 discloses part of the features, but fails disclose the following features. Yeah, we can see most of them are algorithm features. The examiner says that the technical problem to be solved by the distinguished features is how to distribute users' customer service requests more reasonably between a robot customer service and human customer service. Although the above distinguished features involve specific algorithms, but these features and technical features functionally support each other and have interactive relationship. which can save user waiting time and improve user experience. Therefore, the contribution of the distinguished features should be taken into account when examining inventiveness. So the claimed invention is inventiveness. So far, we have finished the case study part. And last, here are some tips for drafting a description and claims for filing in China. If an algorithm, for example, AI algorithm, is applied to a specific technical field, for the claims, the applicant should clarify the physical meaning of the parameters and processing objects of the algorithm. For the specification, you should describe the embodiments in one or more specific scenarios with details. For example, describe the specific examples of input, output, and parameters in the scenario. Describe how to perform operation or specific data or parameters with physical meaning. Please do avoid describing the abstract AI algorithm and then generally saying the algorithm can be applied to one or more technical field. This will not pass the first, subject matter assessment. If the algorithm is not applied to a specific technical field, please associate algorithm features with a specific computer configuration. For example, describe the interaction of algorithm and components of a computer. Describe how the performance of algorithm is restricted by the computer configuration. Use configuration or performance indicators of computer as inputs or parameters of the algorithm. Okay, yeah, that's all. Thanks for listening. Yeah, if you have questions, we can discuss later. Okay.
Thank you so much, Xufang. Really, thank you for your very interesting lecture. I encourage you to use the Q&A button on your screen. We have a few questions there, but we can have more than that. So please encourage you ask your question or raise your issues the Q&A button.
Okay.
To present now a friend, Carlos Sala of Milano. Carlos Sala is a graduate from the Milan Catholic University a few years ago, 1991. He is married with 3 adorable children. Carlo is a lawyer with many years of expertise in many kinds of IP litigation like patents, design, trademark, trade secrets, etc. Carlo is currently a member of the supervisory board of the European Trademark Association ECTA. He is also a member of the Italian group of the AIPPI. He is a very distinguished scholar who teach and related with the academic research. His lecture is very interesting in my eyes. He'll speak about utility models and European Italian patents. So his title is Inventive Step, the strange cage of interplay between patents and utility models in Italian law. Again, I encourage you to have more Q&As, and Carlo, the floor is yours.
Thank you, Eyal. I would like to thank the entire organization, especially our relationship, which always brings fruit to the benefit of everybody. So I will hope I can manage to share my screen. Yeah, I can manage very well. Well, when we speak of the interplay utility models and patents, and Jeffrey spoke of inventiveness, not obviousness, a small step, while Zhao Fang made a hint at utility models. What comes into my mind is the sentence by Harry Truman in 1946. If you can't convince them, confuse them. Because from what I see, from my practical experience, detecting a difference between patents and utility models is never an easy task. Nevertheless, detecting the difference can be a good defense for both defense and plaintiffs, subject to the terms we will see below. I apologize since now if many of my points have been sort of been handled already and therefore and be sort of very much down to earth. I hope that this helps the ones that know less, and at the same time, I apologize again for lack of depth. But nevertheless, let's get to the relevant statutes. Reference, of course, as far as I am concerned, is the Italian Code of Industrial Property, which reflects, starting from 2009, EPC. The scope of application is Italian patents, and now that we have UPC, of course, opted out European patents with limited regard to the national part, and opted in European patents subject to the terms that we further will specify. But let's get to it and get to the actual issue. As as patent practitioners know, there is no definition of patent in European patent law, whether it is national or European, since the national one reflects an implementation of the European via international treaties. We know that there are subject matters and activities that are expressly excluded from patentability, such as software per se, method of treatment, plant and animal variety, and of course inventions, whenever they're a commercial exploitation to be contrary to ordre public or morality. For example, the ones in respect of processes for cloning human beings.
May I interfere? Could you put your presentation in a presentation mode? You know, this small icon on the right?
Well?
No, on the right or below.
This is okay with you?
Yeah, thank you.
Okay, very good. Okay, so, well, there is a definition of patent by WIPO, but this is not a statutory definition, and therefore we may sort of skip it, because it's nothing actually technical. Patent is, of course, an exclusive right related to a product or a process which is capable of industrial application, providing a new and original way of doing something and offering a new and original solution to a technical problem. But let's get to the basic requirements for patentability and validity under the European system. Of course, there must be an invention. Of course, the invention must be susceptible to industrial application. Of course, the invention, in addition to be sufficiently disclosed for its execution by the man skilled in the art, must be new and must involve an inventive step. In our system, an invention is considered to be new if it does not form part of the art. Of course, the difference with inventive step and in considering novelty as distinct from inventive step, it is not permissible unless they're specifically hinted at to combine separate items of prior art together, whilst an invention is held to involve an inventive step if it is not obvious to the skilled person in the light of the state of the art. And instead, inventive step, as it has been already pointed out, as opposed to novelty, and also to you in your presentation, Eyal, has been given grounds also to multiple sources of prior art to be applied in order to see or not whether inventive step is involved. Of course, it is decisive to detect who the person skilled in the art is. That as far as we know, of course, it's a fictitious person, but in cases in court, they are often specifically identified in given entities. Can be a team, has capacity for routine work and experimentation, has no imagination. The person skilled in the art is a dull person, can follow instructions, can correct obvious errors, but has no inventive creativity, knows all the prior art, and is aware of what was common general knowledge in the art at the relevant date. That is, at the date of filing, because the risk, as we'll see, could be an ex post facto analysis. Knowledge of basic handbooks and monographs and references which can direct the reader are okay. Common general knowledge does not specifically refer to specific documents. This has been said. Determination of closest prior art, establishment of objective technical problem, and especially the would-could way of detecting whether inventive step is at play. Would the skilled person consider the claim to be obvious vis-a-vis the objective technical problem? And therefore, the question is whether there is any teaching in the prior art as a whole that would have prompted the skilled person to modify or adapt at closest prior art while taking into account that teaching, the teaching of the prior art, thereby arriving at something falling within the terms of the claim, and thus achieving what the invention achieves. This is the question that is the grounds of the problem solution approach. Obvious is something that does not go beyond the normal progress of technology, but merely follows plainly or logically from the prior art. Something, therefore, that does not involve the exercise of any skill or ability beyond that to be expected of the person skilled in the art. That is, the dull person in the art, if requested to exercise something which goes beyond its unimaginative abilities, well, that is supposed to have inventive step. Of course, that is what we have said already. Beware of post facto analysis. The closest prior art is to be regarded as what the case law of the opposition division of the European Patent Office says, what corresponds to a similar use and requires a minimum structural and functional modifications to arrive at the claimed invention. There is a hierarchy of factors that are to be found in the guidelines, such as same purpose or effect, number of features in commons, which are the work of people having a technical background, not like myself, the guy who goes to court and discuss cases before the local court. I may face on a personal basis this type of issues when I have to detect, when I have to check what the court expert says and what the part expert says in their debate. In that event, we interplay to find out whether this comes into play. In the hierarchy of factors, there is similarity of technical problems are also involved. Most promising Springboard and age of documents are also an important factor. Studying the application, the closest prior art, and the difference in terms of feature between the claim invention and the closest prior art is part of the objective technical problem to be solved. Identifying the technical effect, as we were saying before, is also a major issue, and formulating the technical problems. So we have given a very general overview of what examination, what inventive step is in Europe, in all the European continental systems is. Of course, I will speak of something which is very basic, like the duration and object, 20 years and claims, with description and drawings to be used in the interpretation, because when it comes to utility models, we have a different beast. Because the rules applicable to patents have effect vis-a-vis utility models, but to the extent said rules can be applied to them, which means that the requirements, novelty, industrial application, sufficiency of disclosure are okay, but different is the duration, because when it comes to utility models, we have 10 years from the date of filing. And the subject matter, when involving inventive step, is different, because patents for utility models may be granted to new models apt to provide particularly effectiveness of convenience or application or use for machines or parts thereof, and are to be regarded, even the definition, even if the definition is just an example, is to apply specifically more specifically is going to be applied mostly, not specifically, to conformation, to new forms, and to what is in the strict boundary between dependent inventions and, as I said, utility models. It's a very tiny edge that is in between the two things. But as I will see in a few minutes, it's very useful when defending oneself. Why? Because when we are the plaintiffs and the patent is younger than 10 years, it is possible, whenever there is an objection based on lack of inventive step and the objection is successful, to request the application to convert the patent in a utility model. And this can be done at any moment and at any degree of the judgment or the dispute. And this is also somehow maybe a bit inconsistent, because experience shows that whether it is Italian, in my experience, or German, or Austrian, or French, or Spanish, utility models are often used as priority of European patents. So we may end up having experts or courts issuing opinions or decisions saying that even if a European patent was granted based on the very same rules that apply nationally with regard to inventive step, to decide that that specific patent is instead a utility model with all the limitations in terms of duration that this must imply. One important for patent attorney aspect of utility model, especially when SMEs are involved, can also be, and we're speaking of invention that mostly affect mechanical invention, is that utility models, unlike, let's call them, invention patents, are not subject to patentability examination. Of course, this implies that when you act, some adjustment could be made, but this is useful also to put it, to consider it I mean, business-wise, in terms of money to spend, in terms of balance sheets, whether to put in the assets the existence of patents, and also in terms of a cheaper protection, of course, to the terms and subject to the suggestions that we're going to give. So, as we said, we have the same requirements: novelty, industrial application, sufficiency of disclosure, but with a specific inventive step provision. What is and is shared throughout Europe? I will refer to Italian experience because it is my personal experience, is that the application of patent rules implies that the interpretation of utility model claims follows the same fate as patents, and therefore descriptions and drawings have the purpose of interpreting the claims, which is, as we will see from the examples, could be very relevant. Not in this example, but in the second example. Now, I will come with a case, a funny case. It was Ciufogatto Ossobello, Judge Misratti. Ciufogatto means in Italian mane of cat, and Ossobello means beautiful bone. And the judge was Mrs. Ratz. This was a funny case in itself because we are making jokes on that. And the case related the validity and infringement of this patent, of this European patent, that has a utility model as prior art, the object of which was an article for animals entertainment, in particular pets, provided with an appealing shape, where the characterizing part was given, it was an eatable, was made up with an eatable support material a plastic material obtained from natural polymers that was odorless and could be digested by animals. Odorless and could be digested by animals. According to the court expert implied in the case, this quality of the plastic material being odorless and digestible by the animal were the necessary and sufficient conditions to achieve the purpose. There were an inseparable pair of qualitative aspects of the claim of the independent claim of the patent, and implied an inventive step, albeit a modest one, since this combination was not scaled for the person in the art was not obvious for the person skilled in the art to have the combination of these factors. Nevertheless, what the expert said is that despite the grant of European patent, it was his belief that this combination was just an increase in efficiency and a more efficient use of the tool, the mechanical tool, the product and industrial result. And therefore, in his view, even if a patent, a European patent had been granted, in its view, a utility model set of rules should instead be applied with all the other consequences in terms of duration of protection, 10 years instead of 20 years, and therefore lack of protection in this specific case. I will come to another case. As I said before, it is decisive to have in the claim interpretation to have a careful description, else the risk is that what has been granted as a patent can be then converted into the utility model. The further additional example further clarifies. This is a case of a beating apparatus for beating olives to pluck them, characterized by having these two linkage elements interconnecting, functionally interconnecting, and this patent had been acknowledged in many cases in court of invalidity, but many precedents had considered this patent to be valid, had overlooked the description. And the description of this patent says that this patent discloses a beating apparatus as defined in the preamble of the claim, with the aim to provide a more effective shaking of the branches on which the device acts with respect to currently known apparatuses. Well, if we consider that patents for utility models may be granted for new models up to provide particular effectiveness or convenience, but effectiveness, it has underlined effectiveness, it is clear that if the claim are to be interpreted to descriptions, and claims are clear, legally speaking, clearly declarations of intent by the owner, that in our case, well, it is doubtful whether we are coping with a patent or with a utility model. And since in this specific case, the plaintiff was acting based on a patent that was more than 10 years old, the effect was that the risk was that for the owner to see his injunctive relief be rejected because his action was based on an expired patent. Another example, and I will conclude. We are speaking here of an improved submerged pump. The outcome again was that the court expert was that the patent was devoid of an inventive step, and the other way around, the owner, since the age of the patent was less than 10 years, requested whether the patent at issue had a lesser degree of invalid step, and therefore would produce the effects of utility models. Utility models, as we said, are formal variants of known products that confer on the invention the same greater effectiveness or convenience of application, whilst patents solve technical problems present in the prior art, therefore are supposed to be the creation of something previously known. As a matter of fact, the distinction is very thin. The tendency is to avoid acknowledging utility model acknowledging patent, there is a typo here, patent protection when the degree of inventiveness is low, and see whether utility model protection can be relied on. The tendency is also to acknowledge a utility model protection to products or parts of products which represent a new form. As I said, the difference between patent and patentable inventions is often unclear. For this reason, the strong suggestion is to draft when we are handling, especially this is addressed to patent attorney, mechanical patents, focusing on inventions that are focusing on details of machines. An in-depth analysis of the invention is suggested, and a very careful description can avoid many problems, because, as we said before, claims are to be interpreted in light of the description. And again, this description can be decisive. Well, thank you for your attention. I already spoke about the effect of this set of rules with patents having more than 10 years, and I'm looking forward to hearing to your questions. Thank you again.
Thank you, Carlo, very much. You should stop share your screen. Before we are going to the short Q&A session, I just want to remind everyone that we have in October a wonderful conference in Istanbul. Everyone are welcome to the conference. It will be more than interesting, more than tasty, and more than spiritual. So all of us should come to Istanbul. We, of course, will be there. Now we are in a final Q&A panel. We have quite a lot of questions. I'll begin with the panel with the Xiaofang. You'll be the first, but the panel, of course, can
Okay.
share his opinions. Okay, what's happening? Sorry for that.
Okay. Share.
No. I want to show my presentation. Okay. We are evident that AI AI smears the reality with factual fiction. So people are asking, what are the advancements, the new decisions related with the AIs in patents, and is it more difficult to get a patent as an inventive step in AI in current days? And people also mentioned that the Boost case, is it reflecting the inventive step?
You mean the AI generated inventions can be granted in China? No, the AI generated inventions cannot be granted in China now.
The other member of the panel, do you think there is any chance that it will be patentable in the coming future?
In the United
I don't think
States,
so.
in
Yeah,
the United States, we
actually-
don't have it either. It's the United States, the AI cannot be an inventor. We have some recent case law on that.
Yes, the same. Yes, last year actually the examiners from the Chinese Patent Office had some discussion with us. Yeah, they tend to not granted such inventions because the inventor should be a human. a natural person, yeah, not a machine.
Thank you. Another question by Diego Martin for Jeff and for other member of the panel. How would you compare the practice on plausibility of non-obviousness and inventive step in the US and Europe?
Interesting question, and it goes to how our laws are different and how they are applied. My understanding, and again, I'm going to discuss the UK Patents Act and the European Patent Convention from looking across the ocean, is that plausibility is not actually found in those documents. The doctrine comes out of a case in probably the 1990s where the Board of Appeals said there was no inventive step because it was not credible to believe that the compounds, I think, worked as an herbicide. And about 10 years later, in a case involving Johns Hopkins, the term plausibility was brought up where the board was talking about whether it was plausible that the problem had been solved in the problem solution test. In the United States, we don't apply that test. That's not our standard. We look to, is it in the prior art? But we also have a concept called enablement, which is different from the obviousness test that we apply. And in the United States, we ask the question whether something is enabled, and the statute section 112 talks about how the patent is written. It has requirements for how the document has to be written. And one of the documents is that the application, the specification, has to be written in such full, clear, concise, and exact terms to enable a person of skill in the art to which it pertains to do that invention. And we have a number of tests, and I'm just going to read them off because I never remember all of them, under something called the Wands factors. There are 8 tests: how much experimentation is needed, what guidance is given, whether there's working examples, the nature of the invention, the state of the prior art, that's 5. 6, the level of skill in the art. 7, how predictable, and 8, the breadth of the claims. Because again, in the United States, we keep coming back to what are the claims, because we're being very literal here. So in the US, the enablement test says that the prior art must be enabling and you must enable the claimed invention. And we have a case just came down, I'm going to say 6-7 weeks ago, from our US Supreme Court, Amgen, Sanofi versus Amgen. And that case, the court said, you've enabled a huge body of biologics. Or excuse me, you've claimed a huge body of biologics. You have to enable them. It was essentially a competitive inhibition test of everything that it had a binding. And so if you want a claim that's as broad as everything that performs those bindings or blocks those bindings, then you must enable the scope of your invention. Because again, we're going to be very literal on what the claims are. In UK, EPO, there's more of a gestalt. There's more of a looking at what the technical technical issue is that's being addressed. And so plausibility there is going to, number one, be in the inventive step, not the drafting. And it's going to be looking at whether or not what has been taught and claimed was the problem that was sought to be solved.
I would like to point out one thing, maybe for the listeners to follow. There is a referral that has been put before the enlarged Board of Appeal in EPO. If you want to take notice of it, it's G/, just let me check, I just found it out here because I remember reading something, G2/21.
Yeah.
If you follow suit, you will have the view soon of what most recently the EPO thinks about plausibility.
Yeah, there was a recent British case that came down, and this seems to be on the heels of it.
Yes,
Yeah.
that's right. That's right.
Carlo, a question for you from Diego Martin. Might patent application related to mechanical inventions when the description discloses an increase in the effectiveness when compared to similar prior art devices be requested to be converted to model utility applications by the EPO, or this more typically happens in the judicial instances?
No, this is done nationally. Utility models are being done internally in each country, are not something that is going to be done before the EPO. Of course, what can happen, well, this was the regime until UPC came into force, but let's say that could be a risk when it comes. So let's put it this way: you cannot request it to IPO. This is the straightforward answer to the question. Then utility models, when you have an opted out patents, of course, can be requested and can be converted in each national country. At the same time, the same defenses that I raised with regard to Italy, when it comes to opted in patents, you can raise them before UPC local courts, because UPC local courts are bound amongst the various sources of law to observe also national law.
Thank you for sake of time. I will just.
Eyal, can I add one more shameless plug?
Please, Jeff, please.
Which is the EPO Enlarged Board of Appeal on Plausibility that we referenced, G2/21. The EPO essentially adopted the amicus position that AIPPI submitted. So.
Yeah, thank you. G2/21. Thank you so much.
G2/21.
Yeah, I will just combine three questions. First, by Ran Vogel from Israel. Can there be different inventive step for one claim and inventive step for another claim in the same patent? Another question by Dr. Joe Wise from Israel. Could our lecturers comment on the interaction between inventive step considerations and undue burden, insufficiency of disclosure to a Fushita? And by Tarun Gandhi, a very nice question. I have something to say. Keeping in mind the context of the presentation, please share some tips for the patent attorney to draft an application which will be applicable, acceptable in the most jurisdictions. Those are three questions. I mean, very much combined. May I begin? May I begin with suggest something, and please kill me if you think I'm wrong. If you state that your technology is either or both providing a new degree of freedom to the standard that knows in the art, and or if you show that your technology has a synergistic effect in related to the prior art, in most cases, I might say, your patent will be found inventive. Please can you? Jeff, please give me one hint how to win the case.
Sure. So I would to try to pull all these questions together. I would say to you, think about the WANS factors in terms of what is these 8 factors I just listed. But the question in the United States is going to very much be on a claim by claim basis. And so in the United States, we're going to want to look at either construing claims as Ron asked or how to draft them. You're going to want to write something that's very much claim focused and find support in the specification because we're very literal. UK, UPC, you need to understand the purpose behind the claims. There needs to be more of a drafting of what is the purpose, what is the technical problem being solved in the specification, in the write-up that leads to the claims, as opposed to the being as concerned with the literal ending claim paragraphs. And as such, whether you call it the inventive step analysis or something else, we need an inventive concept that's conveyed and clear from the write-up in terms of the problem solution being very, very directed.
Yeah. Siofan, you present a very nice list of what to avoid, what not to do. So could you please underline at least one thing that you should not do to in order to persuade the examiner that you are having an inventive step in your invention?
You mean what not to do related to algorithm claim or what generally?
Yeah.
Oh, okay. Oh, okay. For inventive step, you know, the Chinese practice is very similar to AIPPI practice, not US one. Yeah, the examiner focus on the original intention of your invention is. Yeah, maybe sometimes in the when making argument, you can see the difference features can solve a technical problem which is not recited in the original description. Maybe the examiner will accept that, but they actually you know emphasize the original intention of the specification. So I will suggest when drafted the original specification, you should be better you know recite the technical effects, the technical problem. It will be helpful when you know in the during office action to explain your difference and your technical effects. Yes.
We have only 1 minute. I want to add another suggestion. It works for me. I don't know if it will work for you. Many years ago, someone asked me to file a patent about a machine that weight your weight. I don't know, it's a scale that weight your weight, but the scale has no numbers on the scale. So you don't know how much, you don't know in real time what is your weight. So you're not intimidated by your weight. So it's usually a scale without numbers is not patentable. So what I did, I looked for a phobia, and I found a scalophobia, a phobia of scales. So this is a very surprising method of treating scalophobia, and the patent is to be granted. So there are so many phobias in the world. So just find your specific phobia, and it will be very helpful for you. The last thing that people ask if we will share the presentations and the video. Cynthia and Maria, do you want to comment on that? How can we retrieve the data?
By sending an email to events@aippi.org, and the video will be available on our YouTube channel.
Send email to event.aippi.org and you'll get the presentation. Thank you very much, Carlos Salax, Yufang Lee, Louis Jeffrey, Maria, and Cynthia from the AIPPI. Thank you so much. 110 or more participants in this webinar. Thank you to the Israeli group. Thank you, the listeners. See you.
Thank you.
Thank
Okay,
you.
see you. Thank you.